Good morning, Mr. Mirsky.
Good morning, Your Honor. Good morning, Your Honors.
Morning.
May it please the Court, David Mirsky for the defendant appellant Dwight Williams. I'd first like to address the issue of the motion to suppress. The problem I see with the motion judge's rulings is that he didn't. The correct standards were not applied. The burden of proof was not properly applied. Not all the evidence was not all examined in the proper light. Under Zerbst and Taylor in the Massachusetts case, the courts must indulge every reasonable presumption against waiver, and it's a heavy burden. And under Van Dusen, the First Circuit case, the burden increases when the suspect refuses to sign a waiver form. In this case, there's a series of events that occurred, and it started with the defendant being removed, woken up early in the morning, removed from his sleep, put on his knees, handcuffed behind his back, first given incomplete Miranda warning that didn't mention that he had a right to have counsel present before questioning, then brought...
Okay, well, let's assume that's true. I know that's in dispute. What consequence was there? Because there was nothing he said at that time until he was brought to the gang unit and then given Miranda again from a form in which all the Miranda warnings were given.
That's a factor, Your Honor. I wouldn't say that it's an overwhelming factor, but it's a factor that I think ought to be considered in the mix of all the events. And
But how? I mean, is your view that if one officer gives an incomplete Miranda warning, nothing is said? An officer later gives a complete Miranda warning, that still does that because the first Miranda warning was incomplete, that he hasn't been given Miranda? I'm trying to figure out what principle you're asking us to accept.
That what's going on is that the defendant's not being told he has a right to counsel before questioning, and he's not being, in this whole scheme of events, he's not being brought to court right away. He's not being placed in a situation where he's going to have counsel appointed. And there are questions about his understanding of what the forms mean. And he appears to place a very strong significance on it. And in the mix of what was before the motion judge, part of what the defendant's hearing early in the morning is not that he has the right to have counsel.
So do I understand you that what you're saying is that even though he got his Miranda rights later on, somehow because he didn't get them all correctly in the first place, somehow that still affected what he said later? Despite the fact he got the later Miranda rights?
Yes, Your Honor. I'm saying that I wouldn't single that out as the overriding issue, because what I think that if you look at all of the series of events, the most important thing, well, aside from that he's in handcuffs behind his back, and that all of the events are important, but they all lead up to him saying he's not sure if he has a lot to say, and after refusing to sign the form. I think that the reason that that's important, to address your question directly, is that there's questions about the knowledge of this defendant, and the motion judge is imputing a lot of information from the limited material he has about prior experience of this defendant, almost wiping out the presumption against waiver. And I don't see that first of all, that there are enough facts to justify.
You don't think it's a fair reading of Judge Chernoff's findings that, to put it one way, that the prior Miranda, the experiences with Miranda is sort of icing on the cake. In other words, if you just remove those, it seems to me that he found that the defendant understood and was competent, and that there was no problem with respect to his ability to comprehend what was going on. I mean, in other words, I just didn't think that the prior Miranda experiences were a key factor in the judge's finding of voluntariness and and effective waiver.
Well, Your Honor, I would disagree, because I think that what the judge is saying, the motion judge is saying, is that the defendant, implying that the defendant knew that his refusal to sign was not effective, but the defendant clearly repeatedly refused to sign, placed a very strong importance on it, and that was his perception. That's evidence that was not. If you look at how the burden was applied, it was not applied as if it raised a question. Whereas on the Van Dusen case, it says that the burden should increase when there's a refusal to sign. And what I'm saying about the first initial incorrect statement is just that there is a if you look at the whole event, this whole event, and you look at it as the arrest and interrogation of this suspect, that an important part of it is that he's not giving counsel, and he's in handcuffs behind his back, and he's not going to be brought to court right away. And it looks like it was very carefully timed to meet, the 6 hours. I mean, it looks like the way that they're testifying, it's exactly timed. And
On a similar, issue, you claim that there was a violation of the right to use the telephone because it was a state trooper's cell phone. But again, similar to the question that Justice Gantz just asked you, what flows from that? Was any evidence offered of anything he said over the telephone? Or was it taped?
Your Honor, what the most important thing about that is just the coercion of it, and
What's the coercion? He was offered the right to use a telephone, question whether he should have been given a regular phone instead of somebody's private cell phone, but
well, that's
what
it.
harm flowed from it in this case?
Well, if he were, first of all, the statute on the right to telephone predates cell phones. I think the last amendment is 1963.
A lot of our statutes predate a lot of our technology.
Yes.
It's causing a lot of problems. But
yes, and well, I think that in my interpretation of the right to use a telephone, what the right to use a telephone was not the same type of, was a much more of a right to contact outside of this room of isolation and interrogation.
But what I'm asking you is assume that we agree with you, that the state trooper shouldn't have given him his cell phone, he should have used a landline phone. What flows? There was no evidence came in that I could see of anything he said on the telephone.
Though, Your Honor, I would agree that there's not. There is evidence, but I would agree that it's not that the evidence flowing from that is not the strongest aspect of that fact. What's important is that the officer's taking away a right that would have lessened the coercion of his situation, and that is a right that the defendant has.
There's less coercion because he uses a landline phone than because he uses a cell phone?
Because he can go, Your Honor, if I can
go
go
further
use,
away.
if I can go use the telephone in the courthouse, in the public,
But I don't
the
think they're
phone.
going to let a defendant who's in custody go outside to use it. I mean, it's
But
just
if I'm
to
gonna-
use the phone on the station desk.
Well, that just, Your Honor, you're going to use my cell phone. If I say you're going to use my cell phone to make calls, that's going to put information on the phone that's not going to happen the same way.
Is it a recorded law? Is it recorded?
The phone is, a cell phone is private, more private to the person who owns it than the station phone. And also, just the circumstances, Your Honor, of whether you're going to be able to, want to be contacting your attorney under those situations where you're told, okay, we're in this room where you're being interrogated, use my cell phone, that's what you're going to do. And then that's the way it was presented. It was, this is what you're going to do if you're going to make calls. I'm going to be here. You're going to use my cell phone. And there's a difference between factually just what the event would be to a person and how much it might provide them with a little more autonomy if they're enabled to use a payphone or whatever kind of
When was he
basic public
formally
phone.
placed under arrest?
Excuse me, Your Honor?
When was he formally placed under arrest?
He was under, it appears that he was under arrest from the beginning in the morning, like when he was,
I mean, he was in custody, or was he actually, when was he charged with the crime of murder?
when was he arraigned or when?
No, when was he
police-
booked at the police station on murder charges?
Or
He was
said
booked
you are
after.
under arrest.
I believe it was after all of the.
These statements.
Yes.
So the telephone right, the statutory telephone right doesn't accrue until he's been formally charged, does it?
The right is when you're brought to the station, Your Honor. And that's what I understood. And the facts are that the officer, Manning, considered this an arrest at that point, just from the way the defendant was pulled out of bed, awakened, and placed in handcuffs and brought down to the station. And he said, Trooper Manning, I believe, said, it's obvious you're under arrest. In that respect, I believe
He was under arrest at that point?
I believe he was
Okay.
under arrest, and that it applies in that way, and
Okay.
that's what it meant. That's where the right to use the phone becomes relevant once you're in the station where the phone is.
Okay, is it your view that the right by statute to use a telephone means that there is a right to have a confidential communication overheard by nobody?
Your Honor, I'm aware that there's cases where overhearing what the person is saying, if he's speaking too loud, and that sort of thing might still be admissible. However, I would say that looking at the statute and looking at the whole point of having the right to a phone call, that implies a power, and all of this really goes back to Miranda. I mean, Miranda is created in order to lessen the coercion in the whole atmosphere.
But the problem with your coercion argument is he's brought to the gang unit in Boston at about 7 o'clock. 8 o'clock, he calls his father. Then he speaks, I'm not sure if he reaches his father. I think he doesn't. Then he speaks to his mother. He tells his mother, have an attorney meet me in court. So he arranges to have an attorney. And then he initiates, after he's brought to Medford, he initiates the discussion with the police officers. So how can you say it's coercive if he's not interrogated except upon his request until following that telephone call? I don't quite see
It's
how...
already happened by the time he initiated, the initiating of further contact. The coercion has already happened by that point. That's later on, and that is, I would say, under Missouri versus Siebert, once you've violated Miranda, once the officers have violated his Miranda rights, and it's basically the same interrogation event that goes on after he asks for contact. They even refer back to the forms and the fact that he didn't sign the forms. And Trooper Manning asks him specifically about things that he allegedly said during the first set of questioning. The coercion was already, the violations already occurred, and this is connected in that the defendant at that point cannot be seen to be making a free will, independent judgment of, having been protected by Miranda when he's just being asked, he's going back over the same information that's part of the same interrogation that was going on before. even to the degree that they want to make clear something about the forms this time, but that still not telling him what is suggested by the Ninth Circuit, that they should, in HELT, that the investigating officers should clearly inform the accused that the failure to sign the waiver form is not going to protect, is not going to keep statements from being used against him. That never happened. Your Honor, I'd like, if I could,
If we could turn to the cross-examination of Mr. Gemma, or Gemma. Mr. Gemma, I gather, had immunity. If the judge had allowed in the questioning as to whether or not he'd been caught with an ounce of cocaine at booking, would that not have immunized him with respect to the charge he was facing?
well, Your Honor, the key thing that he was not, the key thing that was precluded was the nature of the benefit. In other words, how much liability did this person have, and what were they being rescued from by this cooperation, or by providing what the Commonwealth wanted.
But I thought that the judge ultimately allowed him to be cross-examined and to be questioned about the fact that he was facing a mandatory charge on the trafficking, which may have put him in jail for 25 years.
No, that was not it, Your Honor. The judge only allowed cross-examination that, as to the fact that he was facing mandatory time, and he specifically would not let defense counsel ask whether it was a considerable amount of time, and he also would not let him ask whether he was possibly facing 25 years in prison. And since this is appears to be a cocaine offense, a drug offense, and all the details surrounding whatever occurred and what the things that the defense counsel was trying to ask were all matters that could have established the amount of liability this witness had been saved, from by what he was doing, and which is directly shows his bias, and it's really to the point. And I would say, and I cited in my reply brief, the case Napier versus Illinois, partially because the language was appropriate, but also because the Commonwealth really had a duty to let the jury know what this guy was getting, in order to be there, and they objected to this cross-examination, and they kept the jury from hearing it.
But going back to my earlier question with regard to the immunity, I know that you had, I guess the attorney had asked whether he'd been caught with 1 ounce of cocaine at booking. Do you agree that if the judge had allowed him to answer that question, that would have immunized the witness from prosecution as to that charge?
I'm not sure of that, Your Honor. But
Okay, I'm looking at the Commonwealth's brief, on page 42 to 43, and I'll have to ask them, but they write, the defense recalled Gemma and asked him whether he expected to work out a deal on the Suffolk County charges in return for his testimony. He did not. And whether he was facing mandatory time for trafficking cocaine, over 28 grams. I see. So he was simply, that was offered, but not the amount of time that you would get for trafficking. Is that what you're saying?
Yes. As far as immunity, my argument would be whether that he would have been immune or not. I mean, this is just something that this defendant was entitled to know, to have the jury know. I'd like to move on to, if I may, to the issue about the MySpace evidence. The main thing here, there's 2 important aspects of it. First of all, that you can't, from MySpace, you can't know just by what you receive, who sent it. And there was no evidence to show how MySpace works, what computer sent the email, also that there was any kind of affidavit from the sender or some information from the sender, evidence that he
Isn't the real problem a hearsay problem?
It's both, Your Honor. I mean, but I think it's authentication, and also there's another aspect to it. It's the fact that there was a delayed disclosure prevented the jury from hearing really everything about MySpace, and this court isn't really going to get it from the transcript either. The best, the closest is the proffer from defense counsel about it. The case is on you know, it's a problem. I'm citing cases that tell you about MySpace, and I believe that that's not introducing new evidence because it's about a type of evidence, and we have cases on types of evidence, maybe phone call evidence, maybe documentary evidence, and MySpace is a type of evidence. And the Commonwealth kept from this jury, and first of all, they didn't show what that means, and there isn't any real explanation from an expert or somebody from MySpace. I mean, this witness, Ms. Noyes, placed importance on the fact that supposedly the defendant's brother's identity was coming from this MySpace transmission. However, she had no way to know that was him. And the jury has no way.
Mr. Murski, forgive me for interrupting you, but your time is up, so.
Oh, thank you very much, Your Honor. I'm sorry.
That's okay. Thank you. Good morning, Ms. Sylvia.
Good morning, Chief Justice. May it please the Court, my name is Casey Sylvia, and I'm an Assistant District Attorney from Middlesex County, appearing on behalf of the Commonwealth. With me is Assistant District Attorney Elizabeth Keeley, who is the trial prosecutor in this case.
I have a question about the subject with which the other attorney just closed, the MySpace page.
Yes,
When did the prosecutor learn about this MySpace page?
Your Honor, the record on that is that she learned of the fact that some message has been transmitted very close in time to the trial. There's not an exact date in the record as to when.
But it was before the trial.
It was before the trial. We didn't the Commonwealth didn't receive those messages until the day of trial. We didn't
Okay,
have
but
access
just
to them.
well, the Commonwealth knows about it, though. Then why didn't the Commonwealth inform the defendant when they knew about it? And there are ways to get it. I mean, I gather from reading the brief that the woman to whom the message was addressed didn't have access to a computer, or one that would print it out anyway, until trial. But that doesn't prevent the prosecutor from printing it out,
Your Honor,
either from bringing her in earlier to get it printed out or finding out whatever access information he would need.
two things, Your Honor. First of all, it is in the record that the prosecutor had informed defense counsel that there had been communication.
Before trial?
Yes, Your Honor.
Okay.
That there had been communication between the defendant's family members and that witness. He was aware of that.
But specifically an email or whatever this was?
Your Honor, I don't believe
MySpace?
that is in the record. He was aware that there had been some communication, that there had
Well,
been some
no.
intimidation.
You didn't answer my question. That there had been communication or that there had been a MySpace posting or whatever you call
What's
it?
in the record is there had been communication, not that
Okay,
there
so,
had been a
so
MySpace
the
posting.
prosecutor never informed the defense attorney that there was something on MySpace until trial?
That's not in the record. Whether or not she had said it was, what's in the record is there had been communication, not that there had been a MySpace communication specifically.
And
Ms. Sylvia, can I just, a clarification of that?
Of course, Your
The communications, were these sufficient to alert defense counsel that they were communications that could be recovered, whether they were MySpace or emails, but they were not recorded telephone conversations or conversations in the street?
Your Honor, I would say this, that it was sufficient to put defense counsel on notice there had been communication, and that in light of the prevalence of social networking sites, that it couldn't have come as any great surprise that this was the method of communication that was going on.
Okay, so all that the defense attorney was told was that there were communications between some people and noise.
Yes, Your Honor, that's what's in the record.
Okay.
And with
Well,
regards...
don't you think the prosecutor, I mean, how can the prosecutor keep something secret? I mean, suppose the prosecutor just make it much simpler, knew that there were police reports. The prosecutor can't refuse to turn them over just because he or she doesn't have them in his or her possession.
Well, Your Honor, police reports are different because police officers are agents of the prosecution. Also, given the way that MySpace works, there would have been no way for the Commonwealth to retrieve those messages from the witness's inbox.
If
because
the
you need
witness,
password.
if they had brought, the same way they did eventually, they brought the witness into some computer in the courthouse and she retrieved them.
Right, they
Could have
brought her-
done that 2 weeks ago, a month ago.
Well, Your Honor, they brought her in under subpoena to,
Okay, could have subpoenaed her for a hearing.
Your Honor, that would have been a possibility. That wasn't what was done. I'd suggest there was no discovery violation, though, because this wasn't in the Commonwealth's possession, custody, or control.
So is that your main argument, that because it wasn't in the in the Commonwealth's possession, custody, or control, they didn't have an obligation to turn it over?
Yes, Your Honor, that is my position. It was in the custody and control of a third party, Ms. Noyes. And as soon as it was in our possession, custody, and control, we did immediately turn it over to defense counsel. I would also point...
What was the purpose of the Commonwealth to offer that evidence? What was its probative value?
Your Honor, the probative value of that evidence, and my position is excuse me, that it's clear from the record that the reason that testimony was offered went to Ms. Noyes' reluctance to testify, her hesitation on the stand, the plethora of so-called memory gaps that she displayed during her testimony, and that essentially just went to explain that was the only probative value it had, that it was offered for a non-hearsay purpose, and that's quite clear from the record when you look at the record.
I'm sorry, clear from the record because there was a limiting instruction given? I don't think there
No,
was.
Your
Was
Honor.
there? Okay. So it was in for all purposes.
It was in for all purposes, but I think when you look at the record, when you look at the transcripts, the witness says, I don't remember, the words I don't remember 16 times throughout her testimony before that MySpace testimony is elicited. The prosecutor repeatedly refreshes her memory with her grand jury testimony, and immediately after.
I don't dispute that it would be relevant for that limited purpose, but without a limiting instruction, could the jury also have viewed it as consciousness of guilt?
Your Honor, because it wasn't offered for a hearsay purpose, because there was a non-hearsay purpose for which it was admissible, I would suggest this court should uphold its admission. But because if it were hearsay...
The admission is not the issue. The question is, do you need a limiting instruction? And if you don't have a limiting instruction, what flows from that?
Your Honor, defense counsel didn't ask for a limiting instruction here. Defense counsel didn't object on hearsay grounds, so there's no ruling on that. And the motion judge doesn't have any obligation to give a limiting instruction.
No, the question is, does the Commonwealth have an obligation? This is not a let's see how much bad stuff we can get in because we may have incompetent or sleepy or, I mean, that's not the way the Commonwealth is supposed to act.
Yes, Your Honor, I understand that, certainly.
Can we sneak one by?
Yes, Your Honor, I understand what you're saying.
But, I mean, don't you have to start from and I think this is the point in your brief, that you will concede that it could be used substantively since there was no limiting instructions, but since there was no objection, the question is whether there's a substantial likelihood of miscarriage of justice.
Yes, Your Honor, because there's no objection, it does come in for all probative purposes, but that there was an admissible and relevant purpose for which it was offered. But ultimately the question is whether or not any perceived error on the part of this court, if this court perceives any error, whether or not that creates a substantial likelihood of a miscarriage of justice.
Right. And you can see that it was error to not give it a limiting instruction?
No, Your Honor.
Okay, which means that you think it would be admissible then as consciousness of guilt evidence?
No, Your Honor. I don't believe it's admissible as consciousness of guilt evidence. I believe that when there's no objection, it does come in for all probative purposes, but that there's no obligation when there's no objection.
But
No, no,
I mean,
no.
but you've got to get above that. I mean, it is forget whose problem it is. It is an error. It shouldn't have come in for all purposes. It is an error.
Well, Your Honor, I wouldn't agree that it's an error. It shouldn't have come in for all probative purposes, and there was no objection on
But if
part
it
of the defense
shouldn't have-
counsel. So that does lead to whether or not there's a substantial likelihood of a miscarriage of justice. And I'd suggest, based on the totality of this case, when you take this small piece of evidence in the context of all the evidence, that there's no likelihood that justice miscarried, let alone a substantial likelihood.
Right, okay,
that
but
justice
just to
miscarried.
be clear, do you agree that since there was apparently no evidence indicating that the defendant caused his brother to make these MySpace, we'll call them threats, that it would not be appropriate for the jury to have viewed it as consciousness of guilt evidence?
Yes, Your Honor, I agree that would not be an admissible purpose. for the jury
Was
to
the
consider.
consciousness of guilt instruction given?
No, Your Honor, I don't believe so.
So why would there be any issue of consciousness of guilt here?
Your Honor, I believe that the question was whether or not a jury might have viewed it that way, and it might well be that a jury could have viewed it that way. However, I would also point this out. It wasn't argued by either party at all.
The difficulty, and because the trial prosecutors here, we have 33E review, and that is why I started off by saying what the prosecutor should be doing here is not trying to sort of get in stuff that shouldn't be admissible for all purposes and then wait until we say there wasn't a substantial likelihood of a miscarriage of justice. It may not have made any difference if the prosecutor in a straightforward way had said, I want to admit this evidence for the limited purpose that you've just described, and I'd like the jury to be so instructed. No issue. Clean record up here. Instead of dancing around, was it an error, wasn't it an error, if it was an error, was there substantial likelihood, just doesn't cut it. It doesn't cut it.
Your Honor, I certainly appreciate what you're saying. I would suggest, that there's no evidence of any bad faith on the part of the
No. I'm not suggesting bad faith.
Okay. And I take your point, Your Honor. I think that if the Commonwealth were required to explain the basis for the admission of each and every piece of evidence that we offer.
I'm not suggesting that.
But with regards to this type of evidence, Your Honor, certainly, we would have a better record on appeal if that had happened. But that didn't happen. And I don't think that there was any error in it.
Any trial counsel that is attempting to admit evidence should know the basis on which the evidence will be admitted.
Yes, Your Honor.
And sophisticated trial counsel, as I assume trial counsel are in murder one cases, knows this evidence cannot come in for all purposes. I mean, or be prepared to say this is coming in for all purposes. But if you believe it's coming in for all purposes, and you can then explain on appeal why it was coming in for all purposes, there's no need to explain why it's coming in for all purposes. But if you have a pretty good feeling it shouldn't be in for all purposes, then ask for the limiting instruction. It's very straightforward.
Your Honor, I take your point. I do think there is also some obligation on defense counsel, though, to object if they think there's an issue with the evidence. And it's easy for us standing in Boston at the Supreme Judicial Court to say, that it's very obvious this came in for all purposes, but it may well be that given that witness's demeanor on the stand in Woburn Superior Court 3 years ago, that it was obvious to everyone, the jurors, the judge, defense attorney, the prosecutor, that this was coming in for state of mind evidence.
I don't think jurors know the difference between state of mind evidence and consciousness of guilt evidence. They know if a judge turns to them and says, don't consider this for all purposes, you can only consider it for that. And it's the jury as the fact finders that we're focusing on.
Yes, Your Honor. And I do take your point, Your Honor.
If we can turn to the cross-examination of Mr. Gemla, I gather the jury never. Do you agree that the jury never learned that he was facing up to 25 years in prison?
I'm sorry, Your Honor. I didn't hear the beginning.
Sorry.
Of the question.
Do you agree that the jury never learned that he was facing up to 25 years in prison?
That's correct. The jury didn't learn he was facing up to 25 years in prison. The jury learned, the defense attorney was permitted to question Mr. Gemma as to whether or not he was facing mandatory time. And Mr. Gemma's response was, I don't know, I think you'd know better than I did on that. He was also permitted to ask him whether or not he was facing a pretty serious charge at this time. And Mr. Gemma's response was, no, I don't think it's serious. To which counsel responded, trafficking cocaine isn't serious. And he said, no, it's just $10,000 bail. I'll be out in a few days. So, I mean, I think it was quite apparent to everyone what the problems were with Mr. Gemma's credibility. He was an immunized witness. He had an extensive criminal history. He admitted to having shot people in the past. And as to the pending case, defense counsel was allowed to question the witness as to whether he was in jail on a very serious charge. He said it wasn't serious. The nature of that charge, trafficking cocaine in a school zone over 28 grams, whether or not he was facing mandatory time, and whether or not he was expecting favorable treatment from the prosecution in Suffolk for testifying in Middlesex in this case. Defense counsel...
As to the latter point, I gather he said no.
Yes, of course, he said no. Also, the Commonwealth turned over any promises, rewards, or inducements that were given to this witness. And defense counsel agreed during his sidebar that he wasn't allowed to go into the details of that charge. In other words, whether, you know, an ounce of cocaine was pulled off of him at booking. As to the dismissed Suffolk case, there was no real offer of proof as to how that was relevant as to bias. Defense counsel said, you know, I can't go into specifics. Maybe he got a sweetheart deal, but there was no real offer of proof. It was an unrelated case, and I'd suggest it was in the judge's discretion to exclude evidence as to the dismissed Suffolk County case. And I'd also suggest that it was really quite cumulative as to bias. It was extremely evident from Mr. Gemma's testimony what his potential issues with bias were, and also, you know, his potential issues with regards to credibility. I'd like to turn to the motion judge's determination on the motion to suppress. I'd suggest that the motion judge properly denied the defendant's motion to suppress. He properly found that the defendant made a valid oral waiver of Miranda, and the fact that the defendant refused to sign the form or to be tape recorded did not preclude the judge from finding a valid waiver of Miranda took place. And contrary to counsel's assertions, there was no evidence that the defendant placed any particular importance on his refusal to sign those forms. And based on the evidence at the motion to suppress, if he wanted to invoke his rights, he knew how to do so because he'd done so in the past, as the motion judge pointed out in his findings. The circumstance of the interview as a whole demonstrated voluntariness. It was calm, it was polite. The defendant was permitted to use the bathroom. He was offered drinks, he was offered cigarettes. They opened the window, actually, to allow him to smoke. He was allowed to make 3 different phone calls. And in short, there's just absolutely no indication that the defendant's will was overborne in any manner. There's nothing particularly unique or particularly coercive about the fact that the defendant was handcuffed. He's a defendant in a murder case. There's just nothing particularly unique about that. And I also would just like to address the defendant's statement in his brief that Trooper Manning displayed his firearm to the defendant. That just, it didn't happen. He was wearing his service firearm, and that's what the testimony was. And I'd suggest that there's just nothing unusual about an on-duty state trooper who's interrogating a murder suspect having his service firearm holstered at his side. But he certainly did not brandish it in any manner or display it in any manner to the defendant. And I'd also just, I just wanted to touch on the defendant's claims regarding his so-called right to a private telephone call. To the extent that he's claiming that the lack of a private phone call rendered his statement involuntary, he's incorrect. There is no right to a private telephone call in Massachusetts.
When was he actually arrested?
He was arrested at 6 o'clock a.m. At 162 Seaver Street in Boston.
Okay.
He was lying in bed at that time. The troopers came in. They placed him under arrest. They handcuffed him. Trooper Banks read him his Miranda rights, and he was transported to the Boston Anti-Gang Unit, where he was again read his Miranda rights, and he was interrogated at that time.
When was he booked, do you know?
Yes.
When?
Medford?
Excuse me,
12:30?
ma'am?
12:30 in Medford, was he?
That was the formal booking, Your Honor, yes, in Medford. He went for what they call a courtesy booking, I believe at around 9:30 or 10 a.m.
In Boston?
in Boston.
Was he offered a telephone call, to offer the right to make a telephone call within 1 hour of 9:30?
Your Honor, he was offered the right to make a telephone call within 1 hour of being arrested by Trooper Manning.
Within 1 hour of 7 o'clock in the morning or whatever it was you said? Okay.
Yes, Your Honor. So he got that right initially. My understanding is that he was read all of his rights, both in Boston during the courtesy booking and in Medford during the formal booking.
Or twice in Boston.
Yes, Your Honor. I misspoke.
I mean, there was once when he was arrested, 2 in Boston, 1 in Medford, I think. I may have...
That's correct, Your Honor. And I actually counted last night, and he was given his Miranda warnings a total of 5 times that morning.
I knew it was... Yeah.
When you mentioned no right to a private phone call, correct me if I'm wrong, but I recall cases where we've said that police can testify to statements they overhear the defendant making on the phone. So there's certainly no right to a private phone call. Anything he says can be overheard.
Exactly, Your Honor. And those are the cases that I cite in my brief. I also, in my brief, directed the court to a case, Commonwealth v. Dwight, 422 Mass 487, in which the court held that, in fact, the police can, I don't want to say record because I'm afraid that implies something else, but that they can well, they can record the number that's dialed. They can't record the conversation necessarily, but, my contention would be is if you can record the number, it's essentially the same thing as when you make a phone call on a cell phone and that information pops up in your recent calls log. So I don't think there's any substantial difference between the information that's retained on the trooper's cell phone and the information that this court has said, the police can obtain from the telephone call that's made in the police station.
Ms. Sylvia, I have one question. With respect to the sentences for assault with intent to murder and assault with a dangerous weapon, how did the incorrect sentences come about?
Your Honor, I honestly, how do they come about in terms of whether or not...
What was the Commonwealth asking for?
Your Honor, I can report back to the court on that. I do not believe the Commonwealth was asking for 5 to 5 in a day or 10 to 10 in a day, if that's Your Honor's question.
Yeah.
That was what the court imposed on its own. I mean, the focal point obviously was the murder conviction.
No, of course.
I have a question. It doesn't come up in this case, but it made me think about it because of the case. When the police allow the suspect or the defendant at that time to make a telephone call, is that line recorded on which he makes the call or she makes the call?
Your Honor, there's not any evidence of that in the record.
Well, no, it wouldn't be in this case, but I'm just saying normally when one calls the police station, the dispatcher glances, says this is a recorded line, blah, 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 and you hear the beeps. So I'm just wondering I'm just curious.
Right.
It came to my mind, and I don't really know the answer, but it isn't in this case anyway.
Right. Your Honor, honestly, it's something I thought of as well when I was writing the brief, and the answer is that I'm honestly not sure. It may vary from police department to police department. I do know they do record the number that you're dialing. In fact, they make you tell them what it is, and they write it down. So it is something I thought of, particularly because of the recent jail calls cases, and I just honestly don't know the answer and whether or not it's a statewide policy or not.
Thank you, Ms. Sylvia.
Thank you. In sum, I would just ask the court to affirm the conviction for the murder of Isaac Tucker. Thank you.
Good morning, Mr. Campbell.
Good morning.